For such a long time, the concept, or if you like, the idea or principle of jurisdiction has been a very, very crucial element when it comes to discussing issues around the judiciary. Of course, as it has to do with political cases as well, we've seen how many more times than we can count politicians and their various, lawyers have argued about jurisdiction. 1 minute, it's about jurisdiction in one part of the country. The next is also about jurisdiction in another part of the country. And sometimes these are cases that have been long drawn out, in some instances spanning several years. However, how central, or if you like, critical is jurisdiction when it comes to legal matters? We've had to speak with lawyers about this time and again, but interpretation appears to further complicate these concepts. I'm Wiyag Mofwegbe, and as always, it's a delight to welcome you here to the program Scale of Justice on Global Television. My guest is Ademola Oyedoku. He's a lawyer and a legal analyst. He will help us find some context and perspective, breaking these whole concepts down one block at a time for us. I'd like to say a big thank you to you for coming on the program.
Good afternoon, Nigerians. It's my pleasure to be on this station again. It's my pleasure to elucidate on the issue of jurisdiction.
Yes, I can imagine. So let's begin with the elucidation, right? When you talk about jurisdiction, for many non-lawyers, it's just about maybe geography. So you can say, well, jurisdiction is maybe Supreme Court, or Federal High Court or Magistrate Court. Because we have seen cases, for example, where there had been an order from, let's say, Magistrate Courts. And then you see lawyers like yourself say, no way, Magistrate Court lacked jurisdiction. It should have been the High Court. So how is it that even lawyers themselves appear to make that mistake?
See, the best way of breaking down the concept of jurisdiction in a layman's language is to simply put it that jurisdiction simply means the authority of a particular court or a tribunal or an adjudicator to exercise authority or entertain a case. For example now, Special Military Tribunal is established by law. And the law that established it makes certain prescriptions. Who and who are qualified to be the judge of this tribunal? Why did we establish this tribunal? What type of works or cases should they accept or decide? Let's now assume that somebody has a dispute with his bank, now takes the case to military tribunal. It is clearly outside the authority of that tribunal to entertain banker-customer relationship.
Because it's a civil matter.
It's a civil matter. So that is the simplest way of understanding what is jurisdiction. The authority of a court to entertain a particular case or subject matter when a dispute is brought before it. So how do you determine which court has jurisdiction? You as a lawyer, when a case comes to you, you have to run a checklist to know this particular case, which court has jurisdiction. How many courts do we have? Let's start from the highest in Nigeria. We have the Supreme Court, we have the Court of Appeal, we have the Federal High Court and State High Court, we have the National Industrial Court, we have the Customary Court of Appeal, we have Sharia Court of Appeal, then we have the Magistrate Court or other courts that will be established by law of state. So apart from the Constitution Section 6, subsection 6A, that established all these courts, this law, this Constitution has prescribed the areas where each of these courts can exercise power. And when a case comes to you, you as a lawyer, you cannot take, for example now, the jurisdiction of the Court of Appeal is appellate, that is to entertain appeal. So when somebody owes you money or trespasses on your land, you don't file and go to Court of Appeal, because Court of Appeal does not have what we call original jurisdiction. They cannot take a case from beginning. They do not have original jurisdiction. So you will go to a court of first instance, the court that the law or the Constitution has given the power to entertain that particular subject matter. For example, now, issue relating to intellectual property under Section 251 of the Constitution. There are items listed in Section 251 of the Constitution that only Federal High Court can entertain it. So if you take it to High Court of FCT, High Court of Oyo State, High Court of Kaduna or Kano State, they don't have power to entertain such things.
It has to be Federal High Court.
It has to be Federal High Court. One of such things is intellectual property, as I have mentioned. So if somebody breaches your copyright now, or somebody uses your name to pass off his own trade as if it were you,
Right.
no other court has original jurisdiction to entertain it. You go to Federal High Court. So if a decision is made in Federal High Court and either you or the other person is displeased, that is when appellate court, the immediate court of appeal to it, can exercise appellate jurisdiction. So Court of Appeal has no business taking cases from anybody except the person is appealing from High Court or a court of coordinating jurisdiction with High Court. There are cases of land, for example. It's only High Court of States where the matter occur that can entertain land cases. If party A and party B are disputing the ownership of a particular land in Abuja, you cannot take it to Federal High Court because they have exclusive jurisdiction, but their jurisdiction is limited to those things listed under them in the Constitution. So we say they have exclusive and limited jurisdiction. The High Court of States, we also say they have unlimited jurisdiction. They can entertain all subjects, but to the exclusion of those listed for Federal High Court in Section 251. So you take land cases to State High Court.
So in the case of the Abuja, it has to be the High Court of the FCC?
Yes, it has to be High Court of FCT. So issue of jurisdiction is a vast concept that needs to be understood. Now, we have mentioned the court and we have defined it to mean authority of a court to entertain a particular subject matter, either in its original jurisdiction as the court of first instance or in the appellate jurisdiction.
Right.
Therefore, other concept that is important for people to understand what jurisdiction means is that there is this notorious or famous case of Madukolu versus Ikem Dilim. It's a case of 1967 or thereabout. That is where the Supreme Court established what to be considered to know whether a court has jurisdiction over a particular matter. And about three or four things were stated. One, the case you are bringing to a court, has it come to court with due process? Is the court properly constituted? For example, again, for Court of Appeal to do its job, its appellate jurisdiction, for example, to act properly as Court of Appeal, there must be at least 3 justices. Three sitting to determine a case that is coming from High Court to it. It will not be properly constituted if only 2 justices are around and they are sitting over the appeal, because the court has not been properly constituted.
Right.
So the court is not properly constituted, so the case is not properly before the court. The court is not properly exercising its power. In fact, the court is not there. So the court will not have jurisdiction unless it is properly constituted.
Minimum 3.
Minimum 3. So it will not be properly constituted even if the justices are 3. And one of them happens to be my own father and I'm having an issue with you. Because his qualification has been tainted with likelihood of bias.
In your favor?
In my favor. Even if he works the best and does everything perfectly, the case, if it is decided, it will be taken that it has been decided without jurisdiction. That is, the court must be properly constituted. Secondly, the case must come to court. It must be within the subject matter over which that court can exercise its power. For a court to have jurisdiction, properly constituted, and it must be within its statutory duty.
Right.
Now, I see no reason why an area court would be exercising jurisdiction over banker-customer relationship, which ought to be a high court.
Have you seen such case instances? Real time.
See, in this profession, when a client comes to your office and you assess the fact, you appreciate the fact, you evaluate. One of the first things you decide is which court is the most appropriate. There are a couple of times when one lawyer or the other will have made an erroneous decision by going to the wrong court. Then it becomes the first issue to be resolved by the court.
Before going forward.
Another lawyer will come and say, my lord, this case that they have brought to you, you have no jurisdiction to determine this case. Then that's the first argument. No court should take a further step in any case once its jurisdiction has been challenged. Once the jurisdiction of a court is challenged in a case, the standard of Nigerian judicial system is that court should pause everything it's doing and hear argument from both sides, whether to decide and convince itself that I have jurisdiction over this case or I don't have jurisdiction over this case. Because if you continue to do the case, you expend time and resources, and at the end of the day, you later find out that you don't have jurisdiction. Every effort you have made is futile. So it has always happened that people go to wrong court. So we have mentioned that properly constituted, the case must be within its statutory duty that is listed for it as part of its work.
All right.
Then the third one is that the case must come to court following due process of law. The case must come to court following due process of law. Take, for example, before you sue NNPC, the law requires that you give them what we call, before you sue NNPC or a local government, it's part of Nigerian law that before you come to court, you must first give them pre-action notice. State the reason why you want to sue them, tell them the prayer you want the court to decide for you. So then after 30 days, then you can go to court. That means there is a condition precedent before you will have access to that court. So if the condition precedent has not been satisfied, and you rush and file a case to court, it has not come to court following the due process of law. So the case is filed, it has a suit number, but the court has no jurisdiction. Why? Because the case has not come to court following due process.
No pre-action notice.
No pre-action notice, for example. So it has not come to court with following due process of law. And then the court will strike it out because the case, it has no jurisdiction to entertain. It has no power to entertain that kind of case. So we have mentioned properly constituted. We have mentioned it must be within statutory stated duties.
Right.
And we have also mentioned that it comes to court following due process of law. The fourth one is that there must not be any feature in the case. There must not be any feature that can contaminate or destroy it. You get what I mean? Such as the earlier example I give when I was talking about properly constituted. If the number of the presiding justices is okay, the feature that contaminates and removes the jurisdiction of the court is vested interest of one of the justices. If one of them happens to be my own father. So there is a feature that has now destroyed the Constitution. Many other things, apart from all those four basic requirements that you need to consider before you decide whether a court has jurisdiction, there are other things that determines the jurisdiction of court. Take, for example, ouster clauses and limitation law. Limitation law, let me explain that. There is a law, we call it Public Officers Protection Act. It says that when a public officer does anything to you in the course of his duty and you feel wronged, what you should do is that you must go to court within 3 months. After 3 months, if you have not gone to court, you are perpetually barred, you are limited. There is a law that limits the time within which you can go to court.
So that matter becomes status bar, is that the point?
It becomes statute bar. It becomes statute bar. You cannot go to court again.
And this category includes politically exposed people.
Yeah, that means the court has no jurisdiction or authority at that point again. It is not only for public officers. We have different state has its own law regulating the land cases, for example. If you have a land case against somebody who has trespassed on your land, in Abuja and you have not gone to court and it's been 12 years, if you go to court, your case is statute barred. The person becomes the owner of the land. In cases of contract, somebody breached your contract, maybe or debt recovery, somebody is owing you money, and you have not gone to court, and it has been 6 years. If the person denies, the only way you can renew it, if you bring an acknowledgement where the person agree that he has done it maybe in the last 5 years, where maybe he made an assertion that, okay, don't worry, I will pay you. But when the last confirmation or acknowledgement you get from that person is longer than 6 years, your debt has become statute barred. The person is no longer owing you.
So it becomes bad debt.
Even if he's owing you, you have no legal right before the court. There is no court has jurisdiction to entertain the matter. So when we are talking about, so that you can see that one too has affected the authority of the court to entertain the case. Then we have other jurisdictional issue. Take for example now, territorial jurisdiction of the court. The basic thing is that when a dispute arises in a state, it should be the state, the law, the court of that state that will entertain the matter. Somebody committed stealing in Kogi State or committed rape in Kogi State. The victim is in Kogi and the person he raped is in Kogi, and then he escaped to Abuja and is arrested in Abuja. Can police arrest him in Abuja and take him to a court in Abuja?
Why not? Is it not the same Federal Republic of Nigeria?
It's Federal Republic of Nigeria, but the court of FCT has no authority over offense committed in Kogi State.
So go back to Kogi State.
They'll take him back to Kogi State because that is where the offense committed. It's a different thing which we have developed over a period of time when offenses are committed interstate. That some element of offense is committed in Kogi, element of offense is committed in Abuja.
Right.
For example, now somebody steals a car in Kogi and sells it in Abuja. What are the ingredients of offense of theft? One of it is exportation. That is, you touch it without the consent of the owner. Not only that, that's trespass on its own.
Right.
Then you now move it from one place to another. That is exportation, from point A to point B. Point A to point B can be from Kogi, from Okene to Lokoja. You can still be tried. But if you move it from Lokoja now to Abuja, the element of the offenses, part of it is in Kogi, part of it is in Abuja.
So it can be tried in either jurisdiction.
If you now sell it in Abuja, part of the offense, ingredient of offense, is the intention of the person who moved your thing to permanently deny you of it. So if somebody has snatched my phone and run away, and I carry your motorbike without your consent, and I ride it to pursue the thief, clearly my intention is not to escape with your bike. I have intention of bringing it back if after I have caught the
thief.
So you cannot prosecute me for theft. Yes, I've touched your property without your consent. I have moved it far from where you kept it. But to prove that I'm a thief is not complete because I have intention of returning it. So that is no longer theft. You understand my point?
Well.
So we have territorial jurisdiction of court. Offense in a state cannot be tried in another state except...
I want to ask you this just so we can pivot maybe a little. Is it your assessment as a legal practitioner with, several years of experience under your belt, that politicians have, in connivance with some of your colleagues, lawyers, exploited these elements of jurisdiction too, especially in political matters? Maybe by way of delay tactics.
We have had embarrassing situations where there are conflicting orders of court over the same subject matter as it relates to political parties.
Right.
You know why that happens? When we say each state has its own court, high court, that can handle cases that arise from that state. Federal government, Osun State has a high court, Oyo has, Lagos has, Kano has. But federal government is a government too. It has its own high court too. And we call it Federal High Court. And that Federal High Court is one. And its authority covers entire Nigeria. So the headquarters is in Abuja here. That is the Federal High Court. All the justices working or adjudicating unfair cases in the Federal High Court, all of them cannot be concentrated in Abuja. We have Port Harcourt Division. We have Kano Division. We have Enugu. We have Federal High Court in Enugu. We have in Anambra. We have in Osun. We have in Oyo. So Federal High Court is present in almost all the 36 states of the Federation. And they can take, if it is the case that is within their jurisdiction, that is which is listed as part of what they can do, anybody can file that case in any of the states. So the problem now becomes administrative,
right,
which I know Federal High Court is working hard to check. There should be a centralized filing system that when a case is filed that has the name PDP in it or APC or a similar name, the system should be able to immediately pick it and consider other existing case for the court to know whether such cases has been existing before or not. So it used to be manual. And without information to different justices that a case is filed in the Port Harcourt, another one has been filed in Zamfara. Nobody knows. And they will be adjudicating over similar matter, and they come out with different results, which has created embarrassment to judicial. In 2023, there was this practice in the Federal High Court. Anybody who wants to file any political, you have to file it in Abuja. Then the chief judge will now decide to send it to appropriate division to handle it. And that has, in a way, curbed such embarrassing situation. But there are instances that people go to state high court, which is not within the control of the federal authority. So the chief judge of Oyo State will not be able to control the cases filed under the chief judge of FCT. That is where you will see a high court in Ibadan, not federal high court, gives a go-ahead to a faction, and another faction has obtained another order from another state,
countering the first one.
And the courts are not the same. High Court of Oyo State is different with this, maybe 40 justices or 50 or more. They are under one chief judge. That of another state. So it boils down to harmonization of the judicial system. Me, I'm an advocate of digitalizing our filing system. Every judgment that is delivered by court, every order, should be accessible online with or without payment of fee for the public. So we'll be able to check some of these irregularities, but we are still growing. We are not doing too bad.
I want us to, I'd like you to help us understand this idea of coordinate jurisdiction. Help us throw some light on that.
So coordinate jurisdiction means, for example now, when I was mentioning all the hierarchy of courts, I said I started from the highest, which is the Supreme Court, then followed by Court of Appeal. Both of them, they have appellate jurisdiction only, except some election cases that must go to Court of Appeal first. Presidential election.
Presidential, yes.
So you can see now they have original case they can.
From there you can escalate to the Supreme.
To Supreme. You don't need to go to any tribunal. Now, other courts under them, after the Supreme Court, Court of Appeal, Federal High Court is a high court owned by who? Federal government. That it is own high court. For certain subjects that are subjects that is regulated and controlled by federal government. If you want to prosecute somebody now for drug, it's Federal High Court. Because NDLEA belongs to federal government. And many classified cases like that, cybercrime, Federal High Court. Many cases that are specifically for federal government, Federal High Court, and their jurisdiction covers everywhere in Nigeria. So then every state has its own high court too. Does it mean Federal High Court is higher than High Court of a state? No. The remuneration of the justices, their ranking, their coordinate. No one is higher than the other. The only thing that differentiates them is the authority they have, the subject they can treat, what they can handle, the cases they can. You cannot take matrimonial courses to Federal High Court that husband wants to divorce his wife, married in church or court. You cannot go to Federal High Court because it is outside their limited jurisdiction. But that does not mean Federal High Court is higher than High Court of any state. So we have a chief judge of Federal High Court, and for the federal government, and we have the chief judge of every state. So
36 states.
36 states. So the Federal High Court is coordinate to High Court of the state. And the High Court of Osun State is coordinate to that is of the same level, rank, and respect with the High Court of Nasarawa. So High Court of Osun State cannot handle a matter. And Federal High Court will say, I want to check whether he did it well or not. Or High Court of Benue couldn't have decided a matter, and High Court of Lagos will say, bring it, let me check whether he did it well. So they are all court of coordinate, that is the same level of jurisdictional authority. So that is what it's meant by court of coordinate jurisdiction. An appeal from all these courts, and it's not limited to High Court. I've mentioned High Court of Federal High Court. I've mentioned High Court of all the 36 states, right? So any decision from all these court of coordinate jurisdiction that you are displeased with, you can only go to court of appeal, which is above them for review. It's not limited to FCT High Court and State High Court and Federal High Court alone. In every state, apart from the state having high court, the Constitution empowers every state that desires it to have what we call customary court of appeal. Or Sharia court of appeal. So Sharia court of appeal in a state, or customary court of appeal in a state, which we have mostly in the south. Most of the southern states have what we call customary court of appeal. To decide issues of customary law. To decide issue of customary law, which ordinarily High Court will not entertain, because it's specialized court for native law and customs. But they are not below High Court. So the president of customary court in your state has the same status with the chief judge of your state. Because customary court of appeal, in your state, is a court of coordinate jurisdiction with the High Court of your state.
The thing is, each of them has their work cut out for them.
That's why you will see in a state where there is no chief judge in a place to do swearing in for a governor, they will call the president of the customary court to come and do it, because they are coordinate
jurisdiction.
No one is subordinate
to the other.
So they are all coordinate court of jurisdiction. So Sharia court of appeal, customary court of appeal, High Court of a state, Federal High Court, all of them are court of coordinate jurisdiction. And we also call them court of record. From that High Court, customary court of appeal, Sharia court of appeal, all the way to court of appeal, which is above them, to Supreme Court. We call them court of record. Specifically mentioned in the Constitution.
I think we need to put it on record that we appreciate all of these very valuable thoughts that you have shared with us.
Thank you very much.
Professionally, we're grateful. Well, that's what we're leaving it on the program for this edition. We'd like to say a big thank you to you for watching. I'm Muyi Agmo Fuegbe, and our broadcast here on Global Television now continues.